Casac is taking the Judicial Service Commission to court for what it calls unconstitutional interviews of the Constitutional Court Justice nominees. Casac says the manner of questioning of some of the candidates went beyond the bounds of what is permissible to determine the fitness and propriety of the candidates. For more on this, I'm now joined by Dan Mafora, Research Officer at the Council for the Advancement of the South African Constitution. Dan, thanks for your time. We appreciate it. So you go as far as saying that some of the interviewees were ambushed. Just elaborate on that for us.
Sure. Thanks, Shahan, for having me. So the practice at the JSC is that candidates are, if any allegations are made against the candidate, those allegations are put to the candidate before the interview so that they can prepare, so that they are aware and can prepare and be ready to answer at the time that they're interviewed. In this round of interviews, we had a situation where several allegations that were made either by the public or in the interviews themselves were put to candidates for the first time, and they didn't have a chance to consider them, to think about them, and to prepare cogent answers which would have helped them probably traverse the issues better. And so in our view, that kind of questioning where candidates were ambushed with allegations that had never been put to them before was unfair and rendered the process irregular.
But Dan, of course, you would want a thorough questioning of possible candidates for the Constitutional Court.
Sure, but the questioning must be geared towards determining whether or not the candidate is fit and proper for office. And a lot of the questions that were put to the candidates were, to be honest, irrelevant to whether or not they would be good judges or whether or not they were fit for office. But the JSC is set up specifically to, in terms of the Constitution, make sure that people who are adequately or appropriately qualified and fit and proper are appointed as justices. Whether some of the questions that were put to the candidates were just wild speculations, lacking in any kind of factual foundation, any kind of factual grounding, and yet were put to the candidates. And we asked to what end? How does that impact? How does that affect their fitness for office or otherwise?
Yeah, obviously, for the benefit of people who haven't sat through those interviews to listen to those questions, tell us what you think are those irrelevant questions, because many people will be wondering what that is.
Sure. So, for example, in the interview of Judge Unterhalter of the Johannesburg High Court, he was asked whether or not he subscribes to the ideology of Zionism and whether or not he thought that the two-state solution to the Palestine-Israel conflict was, or whether he believed in the two-state solution, so to speak. And one wonders what that has to do with him applying for office. And another thing is the emphasis on the fact that some of the candidates had not acted at the Constitutional Court before. And acting at the Constitutional Court is not a precondition, but the JSC has now brought it or made it a prerequisite in interviews, and have brought it up several times for several candidates, asking them whether or not they had acted at the Constitutional Court. And of course, if just for the sake of the public, acting appointments at the Constitutional Court are made on the invitation of the Chief Justice. So if you are unlucky and the Chief Justice never invites you to act, you then are, in terms of the JSC process at this stage, disqualified. But the Constitution does not require that. It requires that anyone who is adequately qualified and fit and proper should be appointed. And so these are some of the issues that we raised to say, look, this is irregular, and we would like the court to have a look at it and set them aside.
Are you going this route because you have any concerns or red flags about the 5 candidates who were nominated or shortlisted?
Absolutely not. So we make this point quite clear. that we do not have a problem with the candidates who were eventually nominated. And in fact, we say in our papers that we only cite them for their interest. Apologies. But it doesn't matter who gets nominated. It matters too how we get them nominated. So the process is as much an important part of the decision as the decision itself. And so any argument that can be made about, this judge would have not been nominated at all misses the point. It is that, was the interview process fair in that every single candidate who came up before the JSC had a fair chance? And the truth is, when we look at the transcripts, it's not. I mean, you look at how some of the judges were interviewed. Some of the interviews were a lot more rigorous, a lot more robust than the others, a lot more political than the others, and less focused on the actual issues of judicial office. And so we're saying, even if at the end, if we run a fresh process and we still have the same set of nominees, at least we will have known that that process itself was constitutional. And you cannot have a constitutional decision at the end of the day if the process itself was unconstitutional.
Yeah.
So we have no concerns. We think all of them are obviously serving judges, with the exception of Advocate Dodson, who is a practicing advocate. But we obviously think that they are competent and well qualified. We are just worried that the JSC has not discharged its duty, and that it has acted unlawfully in this process. So
when you say some of the questions were political, are you questioning the independence of the JSC then?
Well, I'm questioning the independence. I mean, the JSC is made up of lawyers and politicians. Yeah. And obviously, the politicians took this as a chance to ventilate some of the more political concerns that they had. We had, litigants or commissioners who were litigants before judges asking them about the decision that they took against them. And so, it's a clear conflict of interest for me as a former litigant to sit before a judge in an interview process and say, why did you make this decision when I was a litigant before you? And yet that happened. And with no intervention, unfortunately, from the chairperson of the commission, these questions were allowed to stand, and candidates were prejudiced by them. So we are saying the JSC, in as much as it consists of politicians and lawyers, they all have a duty to vindicate the Constitution, to make sure that they act constitutionally and secure the independence of the judiciary.
I get you. Thank you so much for your time. Appreciate it. That, of course, is Dan Mafora, Research Officer at the Council for the Advancement of the South African Constitution.